Folks, we are welcome to today's session, or this is the first session. I'm really looking forward to today. Welcome joining us. It's a great conversation to be having here. I've got lots to be saying, but lots of questions to be asking Jenna. I'll tell you a little bit about me, and I'm going to introduce Jenna, or Jenna's going to introduce herself to you all. Today's session is being recorded, and I want to make sure that you can use this discussion and these resources, perhaps for your work or even to support yourselves as we go ahead and do this. So I'm just going to say a little bit about me, and then as we're just sort of letting people ease into the conversation in the room. My name is Atif Choudhury. I am dyslexic and dyspraxic and have been my whole life. I came to an understanding of what impact that's had on my life, perhaps in my early 30s. And the challenge for me was really about seeing people of color who looked like me, who could talk about it, and the loneliness of that. I started my life in foster care, moved around a bit. So it affected how I felt about the conversation of belonging, or even if we even had that conversation those days. But it also challenged the way I look at how these things are modeled, and whether they are connected to the cultures and environments that we're born into or travel from. And also I'm very particularly interested, and I've been giving a lecture today at Children in Need around class and how that affects neurodiversity. And it's a big part of my life. And so I'm going to pause there, and things will come up as we discuss this, but I'm really want to take a moment just to introduce, or even invite Jenna to talk about Jenna and why we're doing this today.
Oh, thank you, Atif. First of all, thank you so much for having me. I'm really excited about this session. So as Atif said, I'm Jenna Ide. I'm an employment partner at Thomas Mansfield Solicitors. I have been qualified for nearly 15 years. And for most of that time, I have specialised in disability discrimination. And for the last sort of 13 years or so, I've really specialised in neurodiversity in the workplace. And that interest really kicked off as a result of my dyslexic client's case against Starbucks, which you may have come across before, as it did receive a fair amount of publicity. It was around 12 or 13 years ago. I also have a passion in neurodiversity from a personal perspective, given that many of my family members are neurodivergent.
Thanks, Jenna. I'm going to talk a little bit about the Starbucks case or any other cases that you think are really pertinent. But before we do that, I want to just say as well, look, to so many of you folks joining us, you may be looking at this because of your own diagnosis needs or your own support at work, or which is quite more increasingly common, is your parents. Parents of people who need this support. So neurodiversity itself, I'm want to anchor that, is, for me, I think that everybody is neurodiverse, but we're not all marginalized because of it. And that's the work to do. And we're talking really beyond awareness. It's about global accessibility, conversation, and neurodiversity at work. But why am I calling it beyond awareness? It's mostly because I'm kind of done with awareness. I feel like we do a lot of awareness. So as we go through these questions, we're going to recognize, what does awareness do, to help us understand it? But what are the actual actions that we could be doing as well? And what representation that we have? So to give it some context as well, I will say that on the 21st of May was International Global Accessibility Awareness Day. And it was a great day. And originally we scheduled to hold this conversation on GAD, as it's known, Global Accessibility Awareness Day. And a lot of my work is about anticipatory support, and we'll define what that means. But I want to ask Jenna here, when you think about global accessibility or awareness days themselves, what springs to mind for you?
I mean, most people would probably think about accessibility in the physical sense. So, for example, if someone is in a wheelchair, you'll think about how they might need access to an accessible toilet or a ramp or a lift, for example. But for me, in the context of employment, accessibility is much more than that. Obviously, it does include physical accessibility as well, in terms of perhaps, you know, sensory issues, but in terms of the non-physical side of things, we're looking at communication, how information is provided, and, you know, the operation of policies and processes, you know, even disciplinary or grievance processes, and also culture. So it encapsulates not only the physical side of accessibility, but the non-physical side as well. And of course, these, you know, non-physical, essentially invisible elements can greatly affect those who are neurodivergent. And of course, the knock-on consequences in terms of whether they can meaningfully participate in their employment, or if they're going to struggle. But in terms of communication, if an employer, for example, gives unclear instructions, of course that will result in a huge amount of stress, added time, self-doubt, and of course ultimately could lead to performance issues being raised and potentially dismissal. So communication is such a key part in accessibility. But as I said, I think how information is provided is also really important. And I don't know if we'll come on to the Starbucks case in a moment, but that does have some really good examples of accessibility in terms of the provision of information.
Good. We're gonna make time for it, so we're going to do it. So I guess I'm going to ask a little bit about accessibility in terms of invisible differences. Just before we do that, I want to hold space that we can, as expected in a civil society or an uncivilized one, except for the audience side, but it's natural that people will be wheelchair users and autistic, and perhaps the wheelchair will be noticed. Its needs and a person's needs using a wheelchair might not necessarily be met, but the idea that we have other impacts, autism being one of them, or ADHD and dyslexia, do you feel in terms of accessibility a lot more is being done around hidden differences or coexisting ones?
I mean, I think, you know, as I said, I've been in the neurodiversity space for around 13 years, and at the start there weren't many conversations about neurodiversity in the workplace, but now obviously there is increased awareness. In practice, what I have noticed is this shift from employees who are perhaps struggling under a performance process where they aren't aware of their neurodivergent condition, and they're just really up against it with the process. But that's where I've sometimes been able to identify neurodivergent conditions, and that's really spun the situations round, you know, 180, because obviously that's when the employer becomes aware of the disability, and then, you know, is under a duty to make adjustments and, you know, basically slow things down a lot more in terms of those processes. But more recently, what I have noticed is that there is, as a result of the increased awareness, there are people who have the, you know, the diagnoses, or even if they don't, they're actually more willing to speak up and to share their neurodivergent conditions with their employer. But sadly, what I've been seeing as a result of that, and obviously I do tend to see things where they go wrong on the employee side, but what I'm seeing is that employers are not reacting well at all, if I can put it like that, to employees sharing their neurodivergent conditions. So although individuals have become emboldened and more aware to share, there are still highly contentious situations, and of course this is giving rise to an increased number of tribunal claims in this area as well. I think disability discrimination claims have had one of the largest increases year on year, of recent times.
And so one question I would ask is, do you think that there is a continuous mistake that a lot of employers are making in the UK at the moment?
Yeah, so I think really the sort of biggest mistake that employers are making is they're not approaching the topic of neurodiversity from an organizational level. They're just looking at it on a sort of a piecemeal, individual basis, more of a reactive stance, compared with thinking more generally to see if there are policies or procedures or other types of barriers that are present in the workplace. And the result of this is that individuals are having to essentially put up their hand and have to negotiate with employers for their reasonable adjustments and to allow that accessibility. And those requests can sometimes be viewed as challenges rather than as an amicable way of maintaining that relationship. So for example, if a neurodivergent employee were to ask for communications about their reasonable adjustments to take place in writing, because that is how they'll be able to process this highly sort of sensitive information in a much better way and allow them that time to digest it and then respond thoughtfully. An employer receiving that request to have such communications in writing might then perceive that as a sign of mistrust, or that there might be impending litigation. Because often what happens if you're looking at bringing litigation is you'll want everything in writing, but obviously this is misinterpreted by employers a lot of the time, and they essentially go into defense mode, and the situation turns into this adversarial sort of standoff, as it were, unfortunately.
Yeah, it's really tough, right? It's really tough. What I'm feeling there is, in my mind, from my own experience, but also working in the field for 20 odd years, 30 years, feels like, there is a lot of emotional labor on the person worrying about what to ask for, what the ramifications are if they ask for it. And whilst we talk about reasonable adjustments often, and those of you listening and watching today will be familiar with that term, to my understanding, and I think Jenna might confirm that or not, but a reasonable adjustment request is a reasonable adjustment request in general. But what defines it really is only usually a judge, if there's a tribunal that says this is actually reasonable. And that is at the heart of that is so much risk, because look, folks, I mean, our leaders aren't psychic. The leaders around us aren't psychic. They shouldn't be measured for that. Managers are not psychic. They shouldn't be measured on that. But it is okay to understand that some people have hidden differences, and some people, because of the impact of those differences, or actually because they come from maybe poorer communities, or they're the first of their family to go to university, or this job means so much in terms of helping a family, that they dare not answer things that might be easier elsewhere. This is the intersectional barriers of things. So my question is that, do you feel that people of color perhaps might ask for reasonable adjustments or talk about neurodiversity in tribunals or litigations less so than others? I'm quite curious about that, if you've noticed that, or could
I must say that I haven't particularly paid attention to whether the claimant is of color, for example, and whether there's a pattern there. So it's probably a bit tricky for me to comment on, to be honest. But I mean, Atif, from your experience, it sounds like there are stigmas in particular cultures, and that is something that employers very much need to be aware of.
Yeah, no, absolutely. I mean, folks, I would say this as well, that, you know, quite often I always ask the room that if you can recognize that those, you know, because historically those who have to do more in a workplace to be there, you know, it could be because they're women, because they're black or they're gay, etc. To be in that leadership itself, to make decisions or know that your decisions don't put you at risk. In truth, if you've got to do more to be in a workplace, then you're probably hardwired to share less. So,
Yeah.
so here becomes a challenge that people will disclose and people will share. And I might just play with this a little bit, Jenna.
Yeah.
Yeah. And so disclosure, I've always said, is here's a reasonable adjustment request that I need. And that someone said, well, why will you need that? Now, there's two important things that are really important. Is a person might say, well, because I'm dyslexic or autistic, or they might feel, I'm not sure if I should tell you, you know, but I still need that adjustment. And then it gets into quite a protracted relationship, right?
Yeah. But
in truth, from the recent studies that have been done, and some great studies being done on this, particularly just a big shout to a colleague of ours, is Professor Kim Hock at King's University, who's doing brilliant work on tackling the disability employment gap. But in truth, the reasonable adjustment requests are coming in, even when it's a no, after about 6 weeks. So there's a lot of risk. Those of you listening think, oh, well, if I have to wait 6 weeks, and I've always said 6 weeks for me is 6 weeks of anxiety. I'd worry about, what did I ask for? I wish I hadn't. What are they thinking about my career, et cetera, et cetera. I only ever told a story about being dyslexic or in starting life in foster care or even being poor. I only ever got to talk about that when I started my own company. I dare not tell anyone else. And in truth, and I want to just sort of tease this out a little bit. I think most companies are just deeply unaware of the Equalities Act. And I think most companies work on the idea that the Disability Discrimination Act is what governs them. And what I want to be clear on that is a Disability Discrimination Act is there in 1995 to say, don't discriminate against disabled people. Okay, fine. And it was based on a medical model to a large extent, the label or something. The Equalities Act came along and said, not everyone's going to have a label. You have a duty of care. And you have an anticipatory duty of care. But most organizations don't know that and certainly don't think about it, despite that act being nearly 20 years old, or I think it's 17 years old coming up to. So I guess my question, Jenna, is do you feel I'm right on that?
I mean, a lot of employers do, or a lot of HR professionals I've come across in my career, they will still refer to the DDA. People are under that. You know, maybe it's just that, you know, they've been so used to referring to it that change comes along and it's difficult to get used to. But yeah, I mean, in terms of the Equality Act 2010, there are obviously various legal protections in there, and you know, in terms of reasonable adjustments, it is sort of lagging in terms of, you know, us wanting it to reflect a sort of anticipatory welcome in a, you know, to those in employment, because it does require not only the employer to be aware of the disability, whether that is actual knowledge or what we call constructive knowledge, i.e., you know, they've seen the signs and they ought to have known about the disability. So knowledge is required, whether actual or constructive, but also the employer needs to have knowledge of the what's called the substantial disadvantage, and that, you know, is essentially the barrier that they're facing. So, you know, that could be the requirement of employees to attend the workplace 5 days a week. You know, that could be essentially the barrier to neurodivergent employees. So it's not until the employer is aware of both the disability and the barrier that the duty to make reasonable adjustments comes in to play. I mean, of course, you have got another section of the Equality Act, which is called indirect disability discrimination. Bit of a mouthful there, but that is aimed at looking for, you know, these types of practices that I've just described, and that type of claim can be brought by an employee, even where the employer isn't aware that the employee is disabled. So that has got a slightly wider scope.
Wow.
And actually, in a few years ago, I think it was in 2024, there was a new section brought into the Equality Act, Section 19A. The one I've just been talking about, Section 19, so they just inserted the little A, Section 19A, and that allows someone who isn't even disabled, so they might fall short of meeting the legal test for disability, to bring a claim, you know, for example, in relation to the requirement to work 5 days a week, if they can say that they're facing the same disadvantage as disabled individuals would face, you know, by virtue of that requirement. So there are these sort of wider protections, but that, you know, all of this, it does point the employer towards that anticipatory duty as opposed to the reactive one. But the reasonable adjustment one, as I said, in itself is unfortunately more reactive.
Yeah. And that's what brings me on to a few things. So for my work and the work that happens at Calling All Minds is to teach organizations that the reactive space, A, is not healthy, not for managers, leaders, retention, workflow, or even psychological well-being. But sometimes for a lot of folks, they think, well, that's the only show in town. You know, what else can I do? And I found myself thinking, well, okay, I get it. Because like I said, I might have said it earlier, that we shouldn't be measuring folks for being psychic, because that's not a protected characteristic, and nor should we be measuring people's aptitudes for that. But what I do think is that when we think about hidden differences or physical differences, what we are watching at times is an element of powerlessness and power being differentiated in people. And one of those big things for me is about the resources to tell a story, the resources to say, actually, I live in a social economic environment that informs me of my protection or my rights. It informs me, so it strengthens my participation. I don't believe that that is a given to most people in the country. And I think we don't build policies understanding that or even anticipating it. So what I think an anticipatory welcome is, and we talk a lot about it in our teams, and joyfully, Jenna, you're part of that team as advising us, is we can anticipate that people won't necessarily feel safe to tell a story, or even tell a story when they're asking for an adjustment. We can anticipate that people will live in maybe a job protection mode when they're trying to do that. And I don't think that anybody does job protection that isn't also facing mental health loss, you know? So that might be the avenue of disclosure. But in a better place is sharing. And someone might think, well, sharing and disclosure is the same thing. And I don't think it is. I'll just elaborate a little bit. Sharing for me is when an organizer saying, we are showing cultural competence here, or we are curious as hell about it. We are looking at gender imbalances, and we're not just curious about it, but we're fighting it. We've named it, that the gender pay gap is an issue in this big organization. We are recognizing the disability employment gap, and we are fighting to make that different here, and such and such. This is where we've got a culture of informed, healthy practice, right? And psychological safety being actioned through not just performative days of it's this day or that day, but because it's in the fabric of the organization. And what I personally am really passionate about, and I do check out the work we do, is how we help organizations lean towards universal design learning, you know, and participation. Reasonable adjustments, or adjustments as I prefer to call them, they're always going to be here, because somebody with autism is somebody with autism, and somebody else's autism impacts them differently. It's about the impact of the barrier rather than for me, a lot of times, it's about the impact of it more than the name of it. And if someone says, well, we have an autism policy here, and it's great, but that doesn't look like my autism. Or we have a wheelchair policy here, and it's great, but mine is a powered wheelchair and it won't go through that door, and such and such. So we should have adjustments at the top. But what I'm looking for first is, if we're going to build a culture of sharing, do we really do that through disclosure? Or do we do it where the emotional labor and the real work is done by the organization? And I think what your thoughts might be to that, or comments to that, because it's going to bring me to the next part.
Yeah, no, I completely agree, Atif. You know, the culture needs to be right for someone to feel psychologically safe to share that they are neurodivergent. You know, an employer can have all the policies under the sun and it can look great on paper, but if on a day-to-day basis, you know, you've got verbal instructions being thrown left, right and center, you've got a hot desking situation, you know, it's going to be chaos for someone who is neurodivergent. So it's so important that obviously, you know, employers walk the talk as well as talk the talk. Yeah, absolutely.
It's very powerful, isn't it? I might just slightly move us into something where I think it's really important, that we're watching the country move more towards the idea of workplace adjustments, or workplace passports, as we call them. I know that Georgina on this chat is going to be sharing a very own workplace adjustment passport, which Jenna, I'm grateful for, is one of the advisors to. It's called the Access Passport. And it is based on a social model, not a label model or a medical model, but the social model of what barriers people face. So people can use the passport to just talk about saying, look, I'm in an open planned office. It's great that you want me here 3 days a week, but I'm more effective when I work at home. But if you are asking and you do want me here 3 days a week, for example, then if we can organize noise cancelling headphones, it's not much, you know, or it's somebody feeling really stressed about coming in because they can't get any work done. You know? And so these are the adjustments that we ask. And a person, if I use that example, might say, well, why do you need that? And it might be, oh God, I've got to prove it. But do you have to prove it? Can you just ask? And back to you, Jenna, because I'm going to ask something quite exciting about something you were really powerful in a few years ago. Do you have to just prove it?
I mean, in terms of proving a disability, obviously, you know, you don't have to have a diagnosis. That's something that a lot of people are working on a you know, misunderstanding of. So you don't need a diagnosis, but obviously an employee does have to prove the legal tests of the concept of disability in the Equality Act. So, you know, I suppose coming back to what you're saying, Atif, if someone is changing from, you know, line manager to another line manager, or they, you know, they end up moving to a different department, they don't want to have to keep asking for the same things or explaining the same things, because, you know, it was hard enough for them in the first place, you know, especially if they're late diagnosed, to be able to articulate or even understand what it is they need, let alone to then have to keep repeating themselves. So, you know, anything that can reduce that emotional labor is always going to be, you know, of benefit.
Yeah, absolutely. I fully agree. I'm going to do a shameless plug, but the joy of being able to control who you share something with, your right to privacy and your right to control that information, it has to be digitalized. If it's a Word document that you can't see where it goes, of course, as we talked about already, some communities would question whether they should share that or not, or even disclose it, whatever. So being able to control that information is really, really important. Being able to see who gets it, being able to write what you need to support you rather than what you have to prove is vital. And yes, having a diagnostic, if you've got one and you want to share it, then wonderful. If you've got a personal evacuation plan and you need to share it, then you probably should. But it's just more saying is how you organize that support in your mental health control and your individual choices, I guess.
Yeah.
So, and we're going to watch this more and more, where I do think that the government is changing reasonable adjustment requests and discussions around this, but it's not imminent yet. But there's a lot of healthy discussions about whether reasonable adjustments have to be addressed within 2 weeks. This is a big one, folks. Jenna, what do you think? I know it's not imminent yet. Well,
Yes.
it's being discussed, right? If I get this right,
Yeah,
it's being discussed a lot.
Yeah, it's being discussed within the government, I think. But so the background is, I think that if I've got this right, the Disability Employment Charter proposed that employers should respond, not action, just respond to reasonable adjustment requests within 2 weeks. And so that is what the government is looking into at the moment. We don't know whether that will become the law or not. But obviously, if it does, that will be quite a wake-up call for employers, I think, because a 2-week timescale is relatively short. It will place a greater emphasis on making sure that employers can keep track of requests and that they've got a system to be able to look at how quickly requests are being responded to, whether they're missing that 2-week cutoff. So I think in the spirit of the Employment Rights Act 2025, which is going to be reducing the qualifying period for unfair dismissal claims from 2 years to 6 months, that this is all in the same spirit. It's about pushing the emphasis of discussions to the earlier stages of employment, rather than thinking that they've got 2 years before the employee obtains unfair dismissal rights. They will get these rights, unfair dismissal rights, after only 6 months. So I think that the direction the law is moving in is making it such that employers will have to be having these conversations at a much earlier stage. But obviously, the culture needs to be right for the employee to feel, psychologically safe enough to open up at an early stage of their employment, as we've already touched on.
Yeah, I'm really hopeful for that, for a number of reasons. As someone who's masked, and like many of us listening to the audience, in some capacity in one another, I suppose we all mask a little bit, but it's when we really, really just find ourselves not keeping up with the workload. Throughout the 90s, I used to take work home with me and do it in the weekends and things to keep up. It took its toll on me, but I also felt it was my fault, that I'm not fast enough, rather than recognizing there are tools that I should just ask for. They're out there, and I would dare not. It's really why an access passport matters so much, because people can start navigating or architecturally helping work out what solutions support them. But also in doing so, they're providing data to their employer to say, this is healthy data, that so many people here are neurodivergent. Maybe they don't speak about it, but maybe they should. And this data is helping you anticipate it and keep those folks rather than lose them.
Yeah, and it's giving that data that DEI leaders can use to go to the business and say, look, we're actually receiving X number of requests for this type of support. Actually, maybe we should buy a bulk license rather than just individual licenses, and economies of scale can result. So yeah, it helps, I guess, to put that business case together as well, for not only future increases to accessibility, but also to be able to keep track of all the stats and make sure that they are complying with their legal obligations. Because obviously, if an employer doesn't provide a reasonable adjustment within a timely period, that can be a failure to make a reasonable adjustment in and of itself.
No, Absolutely right. That brings me really onto kind of the conversation about Starbucks a little bit, but it doesn't have to be Starbucks, and we're going to let you explore that a little bit. But I'm aware of the case, and it really brought a lot of, for me, a lot of like profound thinking about where does a giant organization like that, with the resources it has, not meet those needs. And I just wondered if I could just a little bit of time of you exploring that, Jenna, if I understood, it led to an 8-day hearing, right?
That's right. Yeah.
Wow.
8 days.
With the audience, would you share a little bit about that? And I'll
Yeah.
sort of have some questions on it.
Yeah, absolutely. So my client, Miss Kamalchu, who in the context of this discussion, it's worth highlighting, she's Black. She was, you know, prepared to essentially fight for her rights. She, as I said, was dyslexic, and she was a shift supervisor working at Starbucks. So her role included the usual duties of serving customers their drinks, but also carrying out the various health and safety checks that are required behind the scenes at Starbucks that we're all not aware of. And some of those duties included, you know, checking temperatures and writing in the health and safety book. So there was one particular day when she was being assessed, and she made some mistakes in that health and safety notebook. It was, you know, a book, and it was just a manual book where you had to use a pen to write in there and, you know, read the small sort of text in the book. So she made three errors. One was that she wrote the water temperature of a sink that didn't exist, and that's because she'd misread the name of the sink. Secondly, she had put the decimal point in the wrong place with some of the temperature recordings. And thirdly, one of the times that she'd written down at which she'd taken a temperature was incorrect, and it couldn't have been possible because the book had been taken away at that point. So she had been forced to essentially estimate time, which is a particular difficulty for some dyslexic individuals. So she made these three errors, and which all arose from her dyslexia.
Mm-hmm.
And her employer decided to put her through a disciplinary process. So even though she was explaining to them that actually these errors had arisen from her dyslexia, Starbucks decided to give her a final written warning, which was then reduced to a first written warning on appeal, on the internal appeal. But Starbucks held, sorry, the tribunal held that that treatment and giving her the warnings was essentially a type of discrimination. It's called, you know, discrimination arising from a disability. But importantly for our conversation today, in terms of accessibility, which we've discussed, covers, you know, communication, the provision of information, there were some failures to make reasonable adjustments that were found by the tribunal. So the first failure I want to talk to you about was that the disciplinary allegations had been put to her just in handwriting on a piece of paper. So the tribunal held that it ought to have been typed. So the allegations ought to have been typed up for her to assist with, you know, the accessibility of that information. Secondly, the disciplinary minutes were provided to her in extremely small font. So the obvious, you know, essentially free adjustment that Starbucks ought to have done was to provide the minutes in larger font.
Okay.
And thirdly, they sent those disciplinary minutes to her only 2 days before the actual appeal hearing. So again, you know, she didn't have much time to read this small font and process it and to prepare herself for the appeal hearing. So the failure there was, in not providing that document expeditiously. So it really is on point for our discussion today.
Yeah, and so I guess Starbucks sort of, it's weird to keep saying the same name company, but there are other companies that fail on this as well, so it's really important to recognize that. Later, from my understanding of it, the claimant eventually got a diagnosis, right? And at the time didn't have one. Have I got that right?
Yeah, so at the time of these events that I've described, she did not have a diagnosis, but she believed herself to be dyslexic, and she was telling Starbucks, I'm dyslexic, I struggle with X, Y, and Z. So they were, very much aware of, her disability and also the barriers that she was facing. Obviously, as part of the tribunal process, unfortunately, for claimants, they have to go through quite a cumbersome process. If the respondent doesn't concede the issue of disability, the claimant then has to go through this cumbersome process of proving disability, which would involve ideally producing the diagnostic report, which we at that point obtained for her, or she obtained, and we coordinated all of that. So it's not only about the sort of medical evidence, as it were, which is always going to support your case, even if technically a diagnosis isn't required, but also she had to prepare a disability impact statement covering all the elements of the disability test. In the case of a neurodivergent condition, that long-term element of the test is easily ticked. But you do obviously have to prove that there's a mental or physical impairment having a substantial adverse effect on normal day-to-day activities. And as I said, that effect has to be long-term, which usually isn't an issue in neurodivergent cases. So there was a lot of work that we had to do, and that claimants in other cases have to do, just to be able to enforce their rights. And I don't think we've also touched yet on how at the moment the tribunal system is so clogged up. The backlog is just unbelievable at the moment, and you do wonder whether we've reached the point where rights have essentially become worthless. If you can't get to a tribunal hearing within a reasonable amount of time, if you're looking at a hearing in 4 or 5 years time, how does that help you now? So that's another sort of topic to throw into the mix there.
Yeah. So what you're bringing up here is really, I'm so glad she had you, by the way, as a lawyer. That was fantastic. But really what you're touching on is not just about a social injustice, but rather the resources to address a social injustice, and those with the stamina or the appetite, which is really difficult, because when life is lifing and you're coming because you're essentially working in the retail industry, it's not like there's a whole backlog of funds to draw upon to even meet folks like you, and yet this happened. I think it's really powerful. But I also took away from it, and I'll bring up another question, that here it was that where she said I am dyslexic, and that she did not have to evidence it. And folks, again, listening, really lean into that. It's helpful if you can get a diagnosis, even if it is a deficit disorder model, which I personally really push against. But if it gets you some space to legitimize the conversation, then great. But you just saying I am dyslexic, or I am ADHD, or I am autistic, or I am facing barriers, and telling your employer is deeply relevant, even if you cannot prove it at the time. I really want you to feel that and lean into what Jenna's really said there, and what I hope we're encapsulating.
Yeah, because the underlying key issue is whether the employee can show that they meet the underlying tests of essentially the disability test. So if they can show they've got this mental impairment, it does have a substantial adverse effect on their normal day-to-day activities, and that effect is long term, you don't need the diagnosis.
Yeah, that is such a big takeaway. You know, I would really strongly look to many employers and think if they knew that or not, you know, or employees really. I would really, it's such a hallmark case, an 8-day hearing. There was a car, I'd like to have been a fly on the wall. There would have been a lot of debates, you know, and you must have been fantastic in it. So I guess I'm going to touch on again that I'm going to remind the audience, look, that there is an access passport and it is free to use right now. And what we are saying is, if a person had the claimant being able to use a passport to say, these are the barriers I face, I know that you want this right, and we're going to assess that correctly. And I'm absolutely right. I worked in a bank. I promise you folks, I was the world's worst cashier. I mean, there were queues of people in the rain before they couldn't even get into the bank. I was so slow. And it used to really stress me out. And then my cash till would always be out of, and I used to think, am I stealing? It was the men, I know it's nice to laugh about it now, but I used to think, am I just so bad at this that I don't realize that maybe I'm just taking money and that's what the tip, but it was just the wrong thing for me to be doing in a bank. I was really great with customers and they thought, oh, he's so good with customers and they love him. And he gets such great feedback from the clients. Let's put him on the cashier till. No, just leave me with customer care. And I was great.
Yeah.
But if I had a passport to be able to ping round, it was at the Royal Bank of Scotland those days. And they're really good on neurodiversity actually, you know, but not then for sure, and certainly not for me to be able to talk about it. But if I had a passport to be able to say this is why I struggle mentally to keep and why it affects me, if my cash tool is different, then everyone's staying late, do you know? And that puts and they did, and it puts a lot of unpopular pressure on there. And so I'm just asking, can I do this, or can my adjustments be made here? These are things that I think haven't gone away. I think we need people to be able to say, this is what I need in order to get the best out of me. In this country, the research done on mental health research committees, it's 38 billion pounds. 38 billion pounds is spent on mental health loss in the workplace. And I want the audience to know you cannot separate neurodiversity in the workplace from mental health in the workplace. You can never separate them. They're deeply interconnected. And so you've got folks who no longer feel loved in a place, and presenteeism comes, where they're floating along, but they don't feel the needs are ever going to be met or met with enthusiasm. So they just mask some more. And then you've got the mental health toll, which leads to absenteeism. So to not look for reasonable adjustments proactively, to not anticipate it, to not welcome it, because it does inform an organization's process, it strengthens that organization's healthy participation. So to not do those things is a false science. It's actually a loss of money, I think.
Yeah,
but I also think education is the biggest part here, educating HR teams, leaders to do this. So I have a question for you here, and lean on Starbucks or not, or the other cases that you've no doubt worked on. But if there's one thing in UK employment law that you could change tomorrow, what would it be?
So at the moment, in terms of neurodiversity awareness training, employers can just essentially decline to implement it and hope that it won't be classed as a failure to make a reasonable adjustment. Mm-hmm. There was actually a case recently, the Capgemini case, where it was held to be a failure to make a reasonable adjustment. But, you know, on a day-to-day basis, employers can simply say no and obviously hope that a claim isn't brought. So for me, given how there is still work to be done in terms of awareness and understanding, and how it does affect every individual in an organisation, the one thing I would change about employment law in the UK would be to make neurodiversity awareness training for all employees mandatory within the first 3 months of their employment. Wow. And I think it's important that there is that time limit set, because otherwise it would just be one of those things that just gets pushed down the list and it just would never get done. But I think, you know, at least then everyone will at least have attended neurodiversity awareness training, and they'll be much more aware of the types of topics that they need to be aware of. You know, even if it's at a superficial level, you know, we can't expect all employees or managers to be experts in this area, but at least if they're just aware that, you know, for example, if someone sends an email and it comes across as rude and blunt, that actually they may not have intended it to come across that way. Or, you know, if someone interrupts a conversation repeatedly, that's not them being rude, it's because they didn't want to lose their train of thought. So even if it's at a superficial level where they just become aware of the types of topics that would need to be explored or at least recognized, I would really hope that would help to advance, you know, the progress even further.
Well, I'm so with you. The amount of training, and there's so many good organizations out there. You know, we're one of them, but there are others as well. We just need to make sure there's because there's not enough organizations out there doing it for the level of work. You know, needed to get this right. I truly am committed to a social model of inclusion, which does address this, not just through Western pathology or labels, but through healthy participation and what is the barriers in that person's life and environment that makes it hard to be part of this. And that's core to good neurodiversity training, looking at barriers rather than labels. Okay, so we're coming to the end of this, and this is fantastic in so many ways, and it's a real, I don't know, it's a lot of just joy in the way you're talking, Jenna, because you've made things work for people. But it's, you know, it's tough out there. We're watching the Trumpism of the world reach the UK in terms of certain companies not doing more training on neurodiversity, but actually less, you know, actually cutting budgets for inclusion goals that they'd committed to. So that's quite heartbreaking, but we're also seeing at the same time more people coming forward to talk about their needs. So we can't carry on like this. We can't have less money spent on it whilst more people are coming forward to say they need the money spent on it. So my question is to you, knowing that you've experienced this level of, you know, realities and supported so many people facing exclusion or discrimination, and I suppose knowing what you know right now, what's happening right now in the country, here's a question to you, which is a tough one, but what keeps you hopeful?
Oh, that is a tough one. I mean, I suppose what keeps me hopeful is that change is happening. You know, it is slow progress, but it is moving in the right direction. And, you know, as I said, compared with when I started my career in the neurodiversity space, you know, over a decade ago, there's so many more conversations now, so much more awareness. We've really come on a long way in just a decade. So, you know, I'm really hopeful for the next decade that there'll be, you know, equal progress, if not more progress, made. So yeah, I think that's really what keeps me hopeful.
Brilliant. Jenna, that's amazing. I'm going to start closing us down now, but just say, how awesome was that? Look, guys, you've got a lot of reality of what legislation doesn't do well enough. You've got a real sense of why it's just harder for some people, despite the injustice, to bring their stories through. And you've also got a reality that tribunals are quite exhausting and long processes. But we've also got something else. We've got the idea that people are coming together on this conversation. We've got more and more organizations, good organizations, not retracting from the conversation, but doing the opposite, showing that they're deeply curious and deeply committed to this work. And we've got the understanding that we're not just here as people who work somewhere measuring ourselves on productivity. We're actually people here that are looking for our children to feel safe in the world, to be part of something that invites them to be a loved part of it, not based on their productivity or their talent or their superpowers, whatever that means, but really just because everybody deserves everyday belonging, you know, and it belongs to the heart of all of us. So really a big shout from me, a deep gratitude to Jenna, a real wish, an invitation for all of you to take an access passport. Look at Calling All Minds website. I know that Georgina has been typing in the backgrounds for you, and share this podcast to folks, right? Let's keep us all hopeful. We can do this. A disability employment gap can be smashed in this lifetime. Maybe at 36% under a medical model, it doesn't look like it can. But if it was based on a social model and people can start sharing their needs, and we've discovered that it's not about people with disabilities, it's about disabling barriers, then we have a far more interesting conversation. And it's a conversation that's not just intersectional, but it's also intergenerational. So thank you so much from me. Much love to you all. And I hope, you take a lot from this.
Thank you so much, Atif. It's been incredible speaking with you. And yeah, as I echo what you say, hopefully everyone has got something to take away from this. Yeah, thank you very much.
All right. Bye-bye all.
Bye.
And please.
Bye.